And look, mediation is a word that we hear a lot about. Can you give us a bit of understanding around what that is?
So there's non-court ordered mediation, which is where parties just pick a mediator. So let's not go to court, we'll just try and sort that out on our own. We'll have an independent third party kind of running the discussions and negotiations.
Sure. Yeah.
It's pretty, it's not as common, I don't think, as court-ordered mediation. In WA, in all Supreme Court litigation matters, and probably most of the district court ones, in the practice direction say that mediation is one of the first things that the parties are kind of ordered to attend.
Yeah.
And the court will appoint a registrar to run the mediation. I always tell my clients to get to my office about an hour before. We usually have a strategy meeting. We then go across the road to the Supreme Court building. We check out the digs there. We get a nice office set up, and then we pick the nice office with the view of the river and all the rest of it, because that's where we're going to be for most of the day. Then we go into the mediation room, and you have one side of the family sitting on one, plaintiff sitting on one side, the defendant sitting on the other. Sometimes there's a couple of parties and a couple of lawyers, other times there's 14 defendants and half a dozen lawyers in the room. I sit next to my client, and basically the first thing that happens is the registrar explains that everything at the mediation is completely confidential, can't be used against anyone, nothing can be said outside of the mediation room.
Yep.
And then introduces who all the parties are and what their roles are. And then usually in estate matters, the executor is asked to speak first to explain what the current situation is with the administration. Sometimes there are arguments about what the value of the estate is, what are the assets worth, what's the house worth. The best ones are when the estate's all wound up and the cash is sitting in the bank account somewhere, because you just say the estate's worth this much money and there's very little argument about the value. Because obviously the bigger the kitty, the more there is to argue about, and the smaller the kitty, the less there is to argue about. So sometimes the executor is only speaking for 10 minutes, and other times it's a couple of hours to really nut out what are the tax implications of dealing with certain assets and moving things around. And so once the executor's done that situation, had that spiel, sometimes they leave, often they'll ask to be excused. They get called back if they need to come and sign something. And then after that, that's when the plaintiff will give their spiel about why they're in court, what are they doing, what are they asking for, why, and what's their claim. And then the defendants get an opportunity to say what their position is. Then after everyone's said their spiel, there's a bit of chest beating and bravado that goes on, unfortunately, sometimes with some lawyers. And then, not me, but then usually the parties will break off into different their rooms again. And that's where they do a lot of shuttle conferences, shuttle mediations, where they will basically the registrar will go from room to room and they put offers to one another, and sometimes the lawyers will come out of the rooms and we'll sit down together and try and map something out, especially if we're close. And then if we settle, great, we do have a heads of agreement at mediation and it's all done and dusted. If it doesn't settle, then we come back and we have a cheeky beer with the client and we tell them we need to gear up for trial now. It's the big boy stuff. So that's what mediation is. It's a process. You can be there, I say to clients, get the train in or get an Uber or something, because you could be there all day. There's a lot of pressure that's put on the parties. I always tell the clients not to speak directly to the parties on the other side. Don't roll your eyes, don't scoff, don't laugh. You want to be reasonable here because you want to keep the registrar on side, even though they're objective. You just still want to keep people on side. Exactly, and it all comes down to dollars and cents at the end of the day. And you'll see the clients, the light bulb kind of clicks on halfway through the mediation and they get it. But I always say if you've got something that you really, really object to what they've said, just write it down and we'll talk about it in the breakout rooms between us. no one interrupts each other. It's very surprisingly civilised. I mean, the tension, you can often cut the air with a knife, but you know, always public enemy number one. As nice of a bloke I am, but that's just life. And
Wow.
And I guess the silver lining is that 98% or more of all matters settle at or before mediation. So if people really put their best foot forward, I mean, obviously you've got to put some limits on what you're prepared to accept, and you can't be bent over a barrel, so to speak. You've got to be reasonable, but there's a good chance of settling these things at mediation. It's pretty good. Good program.
Yeah.